Good afternoon, ladies and gentlemen. Welcome back to another episode of Property Law Alliance. We are back once again with another informative episode 140, I believe we should be on. We're dealing with two questions today. One will be for Nick, and then one will then later on be for Bruno. The first question, which is for Nick, we deal here with a property sale. Basically, what the purchaser is raising is that there's no building plans, right? And then it comes about that the seller didn't know about this, and then within the midst of all of this, the conveyancers they're insisting on lodging despite the contest that is going on. So then the purchaser obviously wouldn't have bought the property had they known that this exists. And then maybe then Nick, in answering this question, you could possibly touch on how would this then be resolved, what the consequences of an OTP when it comes to common error, and whether when selling a property, voetstoots, and there's no building plans, what can one do? So maybe just come in nicely and let us just give us some information regarding this.
Okay, perfect. So it's one of those classic examples that we have discussed, a couple of times on this particular channel, with regards to what the consequences are. Obviously, there is the reliance that the parties are going to use, and the seller in this particular circumstance is that of voetstoots. Okay, so a voetstoots clause, you're buying the property as it stands, and basically it places a little bit of an obligation on the purchaser to make sure they do their background research before they purchase the particular property. Now, that obviously is what they're going to argue in the circumstances, and that's probably what the conveyancer is relying upon to push through this particular sale, because they're saying, well, it's voetstoots, they want to get their sale through. In this particular instance, there's a little bit of an interesting note which the watcher has given us, and they say that the seller in this particular circumstance didn't know about this lack of building plans. Okay, so now, as I understand it, it's an addition, a room, something that's been added onto the particular house, and that particular section or whatever it is doesn't actually have building plans that were approved. And the seller materially, what it says is the seller didn't know. So one presumes that this additional room or addition was added on by a previous owner of the property. It got sold to the current owner, who is now selling the property, and it's being sold again.
I suppose that's assuming everyone's telling the truth.
That's exactly where I'm going. So the interesting thing about something like this is obviously, because it says that the seller doesn't know, the consequences of the transaction are a little bit different to a circumstance where the seller absolutely knew that there was a lack. Now, we've talked in detail about cases like this before, where if you want to stop the sale or set the sale aside, and you've got to establish some sort of fraudulent misrepresentation on behalf of the seller. So they absolutely knew about the defect. They didn't disclose it purposefully in the transaction. And if you can establish this in front of a court, you have a good chance of setting aside the sale in the circumstances, because you purposefully induced someone to enter into this particular contract. There is fraudulent misrepresentation, you can have that done. But I will go with what the submissions in terms of the question are, and say, okay, maybe the seller didn't know about this particular addition in the circumstances, because this now changes the circumstances. In this case, you aren't able to show, let's say, fraudulent misrepresentation, because you can't prove. And we've talked in the past about the difficulties of cases like this, where you have to establish knowledge and prove knowledge on behalf of the seller. But in this case, we say, okay, well, the seller didn't know, and it's an error in the circumstances. The basic premise is, now it still falls on the purchaser in the circumstances to say, well, look, I've agreed to purchase this property, but in the event that I had known about this particular problem, okay, what would I have done? Would I have entered into the particular transaction? Okay. And in circumstances where there's a common error between both parties, so neither party knew that there was this defect on the particular property, we have a voidable transaction. So a voidable transaction is simply a transaction where the parties can agree to proceed or not to proceed. Okay, and the parties agree between themselves. that's important to remember. The parties to this transaction are not the conveyancing attorneys. The conveyancing attorneys are simply an agent acting on behalf of both parties in the circumstances. Now, that it must be remembered, there is some sufficient case law which the courts came out with a couple of years ago that says, look, when you are acting as a conveyancing attorney, you're acting for both of these parties in the circumstances. There's a lot of assumptions that the conveyancer only ever acts on behalf of the seller in the transaction. It's not correct. Okay, the factual circumstances of a particular transaction do have to be looked at, and the courts have held this. So, in this particular circumstance, it does look, if the conveyancers are insisting that the transaction goes ahead, it's and obviously the person who wrote in is the purchaser in the circumstances. It seems to allude to me that the seller is still trying to push the transaction through. Why wouldn't they? They obviously want their money in terms of the sale agreement. So it seems to be the circumstances. But in respect of avoidable transactions, say we had both parties who are sitting there and going, well, we actually don't want to push this through because of this material defect that we have now found out about the particular property. They can then agree that the agreement, is voided and falls away in the circumstances. Alternatively, they agree, look, yes, there's a defect, but we still want the transaction to go through, and they can push the transaction through in the circumstances. So that's what we mean by avoidable contract. In this particular circumstance, we don't have what the seller's view is. They've given the conveyancer's view, but as I say, the transaction doesn't exist with the conveyancers. They're simply there as a facility to get the property transferred from one party to the other.
Exactly.
In terms of South African law. The seller and the purchaser are the ones that need to make an election. And unfortunately, in this particular circumstance, we don't have what the seller's view is. Okay, I assume that the conveyancer is adjudicating the view of the seller, but in the absence of what the seller actually says, I don't know. There'd have to be some sort of election between those particular parties in the circumstances as a result of the defect, but we'd need more information for that.
Absolutely. No, I agree.
Yeah. Thank you very much, Nick. Obviously, with more information, we are able to give an even more accurate answer. But with what we have, I think that certainly best suits the question. Obviously, highlighting the importance there once again of making sure that whether you're buying or selling a property, you sort of have the right advisors next to you, and you just don't go ahead alone. That sort of just safeguards the process of the property transaction. So we're going to